Been behind bars for over 7 years, accused of killing 10-year-old Janine Nicarico of Naperville. But Rolando Cruz has not given up the battle to prove his innocence. There was never any physical evidence linking Cruz or fellow defendant Alex Hernandez to the murder. Requests were made by the DuPage County Sheriff to repeat lab tests that might disclose physical evidence linking the defendants to the crime. The results of those tests were always negative. The conduct of the state's attorney's office may well be regarded as a campaign to convict innocent men. Hearsay evidence was used extensively. Both defendants were subject to harassment by some jail guards and inmates. The same guards, and also 2 detectives, swore under oath that Cruz and Hernandez made incriminating statements to them. Cruz has steadfastly denied making any such statements. The state's attorney's office relied heavily on the testimony of convicts who used the well-publicized trial as a means of gaining lighter sentences. Not only is the honesty of these witnesses open to question, but their statements, made under oath, contradict each other and the facts of the case. With the exception of one, each of the inmate witnesses has been facing long prison terms for multiple burglaries, yet they all received minimum sentences. Why? 3 state witnesses who had been friends with one or another of the defendants admitted, on record, that they were pressured by the prosecutor to give testimony that was not the truth. 2 have since recanted their original testimony. 1 is too afraid to recant. Despite the numerous incriminating statements that Cruz and Hernandez were alleged to have made, the state's attorney's office and the jail deputies have failed to extract a confession out of either one of them. Each defendant was offered that in return for implicating others, the charges against him would be dropped. Both defendants refused this offer, stating that they could not implicate anyone since they had not been involved in any way with the crime. They were innocent, and they said so over and over again. 4 months after Cruz and Hernandez were sentenced to die, Brian Dugan admitted that he alone killed Janine Nicarico. Dugan knew that none of the information that he disclosed to the Illinois State Police could be used against him. He therefore began unfolding details of the crime. He took a polygraph test and was hypnotized. He gave details never before known about the crime. He described the house, Janine, the abduction and rape, what he had done with the murder objects. He described his shoes and the sheet and blanket taken from the Nicarico home. But the DuPage County State's Attorney's Office would not change its mind. Rather than admit it might have been wrong, or much worse, the DuPage County State's Attorney's Office was forced into the odd position of defending a man who had already brutally killed 2 little girls and 1 young woman, and who had sexually assaulted numerous other victims. A man who undoubtedly would have killed many more innocent people had he not been apprehended by Kane and LaSalle County Police. While all this was happening, Cruz and Hernandez, on death row, began preparing their appeals for a new trial. When the new DNA test came into use, Cruz and Hernandez, along with Stephen Buckley, a 3rd defendant who was free, requested to take the DNA test to prove their innocence. Hernandez and Buckley tested negative. Cruz tested inconclusive, and Dugan tested positive. But Brian Dugan had nothing to worry about. His genetic factors identically matched the genetic factors of the semen recovered from Janine Nicarico's body. He is apparently protected by the DuPage County State's Attorney's Office, which will not admit that it could have been wrong, very wrong. Salvation for Cruz and Hernandez will come from either the Supreme Court or the public. Until then, Cruz and Hernandez seem to be human pawns in a political game.
You've been sleeping. Okay. What were the findings of the Illinois State Police?
Well, they were not actually asked to make a conclusion, but through their testimony subsequently, it was pretty clear that the state police unanimously believe that Brian Dugan did indeed commit this murder and committed it alone.
And yet legally, their findings are not binding upon the state's attorney? Is that how it is?
That's true. They were requested by the state's attorney's office in DuPage County to conduct the investigation, but then the state's attorney's office, because they didn't get the answer they want, apparently just did not accept their findings. And the state police can't really do anything about that. They have testified for the defense in this case where they could, but the state attorney's office just won't accept the results.
Isn't the police captain under investigation now?
Yeah, the state attorney's office not only did not accept the conclusion of the state police, they passed along an accusation that Ed Sazowski had somehow coached Brian Dugan in his answers, rather than accept that Brian Dugan actually committed the crime. It was passed along to the Attorney General's office, and the Attorney General's office began an investigation more than 2 years ago. They still have not actually formally concluded it. But you'd have to ask, well, how would Ed Sazowski have coached Brian Dugan on the size of his feet, his DNA, the fact that he skipped work on the day of the crime, the type of car he drove, and so on.
And the hypnotist and the polygrapher.
Yeah, it's an extremely untenable position. But that was their response to the state police investigation. The state police spent 3 months investigating it. They generated 857 pages of reports, and their conclusion was pretty clear. And instead of accepting it, the state attorney's office didn't get the answer they liked, so instead they accused the state police of gross malfeasance in the investigation, accusations which have never been proved and never really had any evidence to show that they were real.
This is really truly shocking. I've shared this with some people, and I hear time and time again, can this be happening in the United States of America? And regretfully, it's happening, and I guess the rate of error is sometimes close to 5%. Cruz and Hernandez have definitely been victims of political circumstances. They're very good prey. They're Hispanic, they're poor, they couldn't afford a lawyer, and it's very difficult for them to prove their innocence, even though there's no question about the fact that they are innocent. I hope that this program sheds some light on this case and enables some people in the public to perhaps act and do something to help those two young men who are sitting on death row and are trying to tell the world that they are innocent. And I hope one day they can do it and prove this.
Well, thanks for your help also. And if they are ever going to be shown to be innocent victims of it, it'll be because of people who are working to get the information out. It
will only come from the public. There is no question about it, because the state's attorney's office has had the opportunity and they just would not. They passed it. And in fact, in the Dana Schnorr case, there was a different suspect and they acknowledged.
Yeah, it's interesting. Kane County had a very similar case in the sense that it was a rape murder of a 27-year-old nurse, Dana Schnorr, and the police believed that they knew who did it, an ex-boyfriend of Dana Schnorr's, who happened to live in the area where the body was found, and had arguments with her and so on, but they could never prove it. Different from DuPage County, they didn't try to prove it, in the sense that they didn't go out and try to get jailhouse testimony, have changing witnesses' testimony and so on. They let it go, and they watched. And when Brian Dugan was caught, they decided to look into him, and when he confessed to it and all of the factors matched, they accepted the fact that he had committed the murder, and they accepted his plea agreement for pleading guilty to the murder. That's very different from the way DuPage County did it. In the same situation, They wouldn't accept the fact that they really didn't know what happened, so they went after the wrong men and created a case out of nothing. And when Brian Dugan came forward, now it's too late, and they won't accept the fact that they made a mistake.
Thank you very much. And we hope that you, the public, get involved. Because if it can happen to Rolando Cruz and Alex Hernandez, it can happen to anyone.
Well, thank you for having me on.
Thank you. Welcome to the fourth segment in a series of investigatory interviews on the Nicaragua murder case. Our focus today will be on the investigative aspects of this case. We're going to look in great detail at how is it possible that two juries could find Rolando Cruz guilty of murder. We're going to describe some of the witnesses who testified for the state. We're going to examine what information the jury did not have when they were making their decision to find Rolando Cruz guilty of this brutal killing. Our guest today is Jed Rea, a private investigator who, before entering the private field, worked for the U.S. Attorney's Office in various capacities for 7 years, and also worked for 1 year with the Secret Service. You've now seen both sides of the fence. Your approach to your work is that of a law enforcement man.
That's correct.
And you can't change your skin and your training. And I feel very, very privileged to be able to share with the public some of your experiences as a private investigator. I would like to confess that it took a little coaxing to get you to talk, but it's because you came to realize that Rolando Cruz was 100% innocent that you were willing to come today and discuss your role as an investigator in this case.
Yes.
Could you discuss perhaps the evolution of your thoughts or your opinion about Rolando Cruz as you began investigating?
My opinion as to whether or not he was involved in the case, is that what you mean? Well, initially when I was appointed, our primary focus was to develop evidence that would show that Brian Dugan, the gentleman who's confessed to this crime, was alone responsible for it. We pursued our investigation, which took several months and resulted in a hearing in August of 1989, I believe. And subsequent to our being allowed to use the Dugan evidence in our defense case, I then turned my attention to the state's evidence against Mr. Cruz.
Why was the state so adamant to not allowing the Brian Dugan information in? After all, for 5 years they said he didn't do it, he's a liar. Why were they concerned?
Well, I'm sure their overriding concern was that this would weaken their case against Mr. Cruz substantially.
Do you think?
Once I got into the case and reviewed the boxes of documents, I was fairly impressed that Brian Dugan probably was responsible for this crime alone. The green car, which he owned, the fact that he was off work on that day and told law enforcement authorities of that without obviously having had time to go and check with his former employer to make sure he was off that Friday. The fact that any witness to any event leading up to or just after the crime only saw one white male in a green car, to me was, and plus it was, most importantly, I guess I shouldn't overlook, it was very consistent with his method of operation.
Okay. Now, you were the investigator for the second trial, which took place in 1990.
Yes.
And there were a number of investigators from the Public Defender's Office who had done, a substantial amount of investigation for the first trial.
Yes.
So I guess some of that information was already available, and you didn't really have to duplicate their findings.
Some was available, but and I'm not sure, I don't remember the exact number of witnesses who testified for the state at the second trial, but quite a few of the witnesses were new witnesses who did not testify at the first trial.
Okay, what I'd like to do then is look at the evidence against Cruz and his co-defendants on March 9th of 1984, when the state, 9 days or 10 days before primary elections,
Yes.
notifies the public, we've got the right guys. And in their announcement, the prosecutor said that he would ask for a sentence of death upon conviction. On March 19th, 10 days after that, the three defendants were brought to the courthouse for the first time. I believe in a state of shock, especially Hernandez and Buckley. Cruz was adamant and mad with this whole thing. And at that point, the prosecutor says, I have 6 boxes of evidence right here in front of me, and the culmination of my investigation. What I'd like us to share with the viewers is what really was the evidence against Cruz on March 9th, 1984. And the direct evidence against him was really 2 witnesses. There was Ramon Mares, who was his distant relative,
Yes.
and a Daniel Fuller, who was a friend of his for a while. If we could look at those 2 people, because they are the people who really brought Rolando into this case.
Ramon Mares contended that he had had a conversation with Cruz that took place in a car. It's not clear when this conversation took place, and I think Mares gave testimony that it took place at various times.
He spoke about a party.
It was at a party, supposedly for Cruz's then-girlfriend, bottom line is it would have had to have been between February 25th, 1983 and the beginning of August 1983 when Mr. Cruz was incarcerated.
He couldn't give specific...
Well, in one statement, I remember he said it was early fall or the beginning of the winter, which are 2 different times, but he did say it was cold out. If it occurred, I assume it would have had to have been late February or March or April. But the substance of the conversation was that Cruz confided in Mares that Cruz knew the person, singular, responsible, and that he was going to get him. Mares said that Cruz was very emotional about this. There's probably little question that Cruz, Mares talked about their having gotten beers and they were partying. So, I mean, if and when this conversation occurred, I mean, Cruz was probably intoxicated or stoned, as the term is used for drug use or whatever.
Okay. Did Cruz say that he was there, as far as the Maris testimony goes?
In the initial trial, that was Mare's testimony. Mares has since, and just prior to the second trial, has changed his story, has admitted that he lied under oath, that he committed perjury at the first trial. His statement now is that Cruz only said he knew the person responsible and that he was going to get him, or words to that effect. Mares now says that I only continued my lie because there were some individuals in whom I confided that Cruz had said he was there. So I didn't want to go back on my lie and lose face. More importantly, Mares also acknowledges that the fact that there was a $10,000 reward was something that was played heavily in his mind, and that he might have access to it by providing the linchpin testimony in the case. He also says now that he went to the prosecution just prior to the first trial, and that would have been probably January of '85, around that time, and told them that he had lied in the grand jury and lied to the detectives for the DuPage County Sheriff's Police regarding Mr. Cruz having said he was there.
Now, John, he's the only person who has recanted out of about 10 witnesses, and he's the only witness who has become a born-again Christian.
That's correct. He did say that.
Which means that we would have to convert a number of people back to the good old faith to perhaps change this whole thing and get the truth out.
If that's what it takes, well, then maybe that's what we'll have to do. But I just wanted to finish this point because Mares said that he felt intimidated by the prosecutors because they then held the threat of perjury over him, and therefore he stuck with his story at the first trial. What concerns me is that I'm not an attorney, but I think that the rules of discovery dictate that the prosecutors should have told the defense attorneys that Mr. Mares is now saying Cruz wasn't. Cruz never said he was there. Cruz never said that they used tape on her. Cruz never, because he went through a litany of supposed events regarding the case in the grand jury that supposedly showed knowledge on Cruz's part as to the commission of the crime. Mares admitted that he read things in the paper, so he knew these things from there.
As did many other witnesses.
Correct. Now, this was the most publicized case in DuPage history, I would imagine.
Let's listen to some of Ramon Mares's recantation.
7th, 1989, time is 11:45 p.m. Present, Ramon Mares, Tom Waters, Shannon Thomas. Ramon, do you mind if I record this interview? No, I don't. Ramon, what is your full name? Ramon Mares III. And do you also go by the name of Chuck? Yes. Ramon, we've been sitting here discussing what you knew about and what you've been told about an incident up in Illinois. Would you tell me what we talked about, what was told to you? He told me, he says, Chuck, that he wanted to tell me something. And I said, well, what about? He said, it's about that little girl in the neighborhood. I told him, well, what about it? Well, what about it? And he says, I know who done it. I told him, done what? Who killed her? And he says, I know who killed her. And I'm going to get him. I want to get him. He's going to pay for what he did. And he just started crying. I mean, his first word when he told me that he knew who done it, it was just tears. It was just, he went emotional and he started crying real bad. And when he said that real strong, like he was very angry, and he really meant it. And he said that very loud and clear that I do remember that. I recall the time when I believe there were two state's attorney officers who talked to you about this. One a Patrick King and one a Tom Knight. Two individuals, and I think it was just prior to the trial, the day before maybe, when they had you into their office. Right. And what happened then when you tried to explain this to them? they had long before the trial. They briefed me about what I had said and what the questions they had asked me. And when they asked me about him saying that he was there, I tried correcting myself at that time and telling him that I wasn't sure if he said he was there or he said he wasn't. And when I told him that, I can't recall who it was that was asking me this, but he got upset. He threw the papers or the pamphlet of what I said earlier in the questioning. He threw those on the table, and he told me, he said, he started cussing at me and getting mad and telling me who was pressuring me, who was harassing me into changing the story. And I told him nobody, and he just got all upset and kept yelling, and so I started yelling back at him, and then this other, I don't know if he was another attorney or another officer, he told, I'm not sure if it was Knight or King, he told him to mellow out. He told me to step out of the room with him for me to mellow out, to just to calm down. And after that, we went into court, and I just said what was on the paper, what I had said earlier. Between the two of them, was it the taller one or the shorter one that started cussing at you in there? It was the shorter one. Okay. We'll read some of your testimony here. This is page 91. He said, do you remember the killing of the little girl from Naperville? And I said, yes, I heard about it. What about it? And he said, Chuck, don't tell nobody, but I was there, but I didn't kill her. Now, is that correct? Chuck, don't tell nobody, but I was there, and I didn't kill her? No. Okay, listen to this question and your answer. Question, what did he do or say at that time? Answer, nothing. He just would tell me that he was there and that he didn't kill her. Is that true or correct? No, that's not true. What's not true about that? He didn't tell me that he was there, and that's not all that he kept saying. Okay. Question, how did he say that, if you can recall? Answer, he told me, Chuck, I was there, but I didn't kill her, that's all. Again, is that true or correct? No, it's not correct. Okay. Why did you make that statement then? I was just scared and just trying to say anything I could say that they wanted to hear.
Let's move on to Daniel Fowler. He was a friend of Cruz, and they met around May, in fact, around Cruz's birthday, although I believe now that it wasn't Cruz's birthday because Cruz was with someone else on his birthday. But,
right.
In the testimony, we met because it was Rolando's birthday.
That's correct.
At the time, Rolando had been working with two detectives. I don't know how emotionally involved he was with them or how excited he was about this opportunity to be helping the police in this, investigation.
Yes.
But it sounds like he did share it with a couple of friends, Ramon Mares and, in this case, Fowler, whom he trusted. And this confidence that he had in those friends of sharing with them the fact that he thinks he knows who did it evolved in no time into
he was there and he did it.
He was there.
And he was with them when they did it, correct, which makes him accountable and just as guilty as the principal.
He had two different testimonies in the morning grand jury and in the afternoon grand jury.
That's correct.
And he testified, and he was approached by both the investigator, Bob Moll, and the attorney, Tom Laz.
Tom Laz.
And he told them both separately that he was coerced and he was afraid. By the time he testified in the trial in 1990, when you were an investigator, he couldn't even remember talking to Bob Moll or to
That's
Tom Laz.
correct. He basically said that he had no recollection of having talked to the public defender or his investigator, which seemed kind of incredulous. I mean, he was terribly nervous on the witness stand. I noticed that about him, but I don't know whether he was lying intentionally or whether he just honestly didn't remember. But the fact is, he did talk to those gentlemen. There was a report prepared by Mr. Mull. I know that.
At this point, the evidence against Cruz is two friends who really were trying to say, Rolando told us he thinks he knows who did it, and I believe he thought Alex Hernandez did it. These were the rumors.
That's what I was reading into between the lines in Cruz's statements to Fowler and Mares.
So this is basically it. There were some people who incriminated him as far as his personality, but there was no one else on March 9th who actually said, who incriminated him as far as the murder is concerned. The statements that supposedly Rolando Cruz said against Alex Hernandez, or vice versa, were all developed after the
post-indictment. Post-indictment, that's correct. They were. You're right.
On indictment day, they were each offered the chance to testify, the opportunity to testify against each other in return for charges dropped.
None of them took the deal. That, to me, is the first sign that that these fellows are not responsible. These are three gentlemen who, at that time in their lives, were basically losers. I mean, I come to know Mr. Cruz, and he's a nice guy, but at the time, these fellows had nothing to lose and everything to gain, and the prospect of getting a $10,000 reward or of not facing the death penalty, if one of them or any of them had been involved, I mean, they would have jumped at the chance. You just can't tell me that three fellows who basically knew each other marginally, and Cruz and Hernandez actually do not like each other. I mean, that should have sent up some red flags to the prosecution, which it did, I mean, to some of the investigators on the case. But that just doesn't happen. I mean, if you look at how cases are made, it's usually with the testimony of a participant.
We are a year after the murder. There are two witnesses, Daniel Fowler and Ramon Mares.
Yes.
And there is no confession. No one wants to testify against the other. But all of a sudden, between March 9th and trial day, Rolando has made several statements to a number of people. And we are now moving into the jail phase where he supposedly made incriminated statements to Stephen Ford. Later on, another inmate by the name of Stephen Pecoraro, which was the jury never heard. They only heard him. He was only heard at sentencing and then in the second trial.
Yes.
And 3 police officers. So let's discuss this new phase in the development of evidence against Cruz. Okay, so we're looking at Stephen Ford, an inmate. Could you discuss him a little bit?
Stephen Ford was in the same pod, I believe they call them, at the DuPage County Jail with Mr. Cruz and probably about 15 or so or 20 other inmates. Cruz and Ford were not friends from what we can tell. In fact, apparently at some point, according to Mr. Cruz, they were not enemies, but they certainly had differences of opinion based on the attempted sexual assault that almost took place at the jail.
Which was unrelated, which had nothing to do with Cruz.
Nothing to do at all with Cruz. However, it placed Cruz in a position of sticking up for the intended victim.
Okay. You never had the opportunity to speak to Ford. Did you see him on the?
I did not. Well, let me believe I did see him testify. That's correct. I did talk to him once prior to this second trial. I had a brief telephone conversation with him wherein he basically told me that he first had to check with the state's attorney to see if he could speak with me. I realized I was not going to be able to talk to him because that was his way of telling me he wasn't going to talk to me, and I never heard from him again, even though he said he would call. He was living is living somewhere east of Illinois.
Ohio.
That's correct.
if he received some kind of a good plea bargain for his role?
Well, they can argue that he didn't, but if you look at what transpired, he was in jail charged with 5 or 6 residential burglaries.
Which would give you how many years in?
Well, I'm not familiar with their felonies, of course, and they all carry periods of incarceration. He ended up having a deal made where he pleaded guilty to one of these residential burglaries. I can't recall the exact amount of time, although he did get sentenced to some amount of time greater than a year, I believe, because he was shipped out to another Illinois Department of Corrections facility. However, pleading guilty to one residential burglary when they have you on 6 or 5, that's a good deal. Any lawyer would take that for his client.
Okay.
There's no, of course...
Now, his testimony is interesting. It's really not that incriminating, but if you add that to other pieces
Correct.
of evidence, it can add something. He speaks about Rolando living in the woods,
Yes.
trying to imply knowledge of the Prairie Path area,
Yes.
of Rolando regarding that rape that occurred. If it happened to me, I would make sure that if it happened again, I would make sure that the witnesses were all killed.
Yeah, that the person would be killed, something to that effect, yes.
Which makes you look at Rolando Cruz as a very vicious
Right, a person who has the capacity to kill somebody.
And
right.
the prosecutor played a great deal around this one. He wanted to put this in, bring this to the jury, and the defense could not stop him from doing that.
True.
He also said, yes, I kind of killed a girl in Aurora. Now, what does that mean?
That's correct. What does that mean? I don't know. I don't think Mr. Cruz...
Do you think that they were asking him, well, did Rolando Cruz ever tell you that he killed a girl, and maybe he kind of wanted to...
There's definitely ways of explaining all those statements. First, if you go under the supposition that Mr. Cruz made all those statements, I don't know whether he did or not, but as you said, you can explain those all away. Well, if I kind of killed the girl in Aurora, meaning I'm here because they've charged me with doing something I didn't do, so yeah, I guess I did kind of, I mean, it's...
Yeah, it could be interpreted in different ways.
It could.
What about the witness you brought from Florida who testified against Stephen Ford in regards to all this?
Basically, Mr. Fernandez's testimony was that he was present on occasions in the pod. He was incarcerated on some other charge, and that he never heard Mr. Cruz make any of these statements in conversations with Mr. Ford.
It's also interesting that he paid his own way back to Illinois from Florida in the first trial, and he wasn't even friendly with Cruz. He didn't like Cruz.
Yeah. Yeah, I was impressed by that, and he was very cooperative in the second trial because we, as with every witness, you bring them up here and they never testify when they're scheduled to because that's the way trials work. But he was very patient, understanding, and hung around and got up in the stand and told the truth.
This was really touching to me because we've seen so many people. We've seen human frailty at its worst in this case. People willing to say anything for whatever reason. And here comes a man who was a convict. As I said, in the first trial, paid his own way to testify for Cruz and didn't like Cruz. I mean, this is
yeah,
really,
that was great.
Stephen Pecoraro testified at sentencing, and both him and later on Robert Turner had some vicious and very incriminating information.
Stephen Pecoraro and Robert Turner, that's correct. They did. Stephen Pecoraro wrote a letter to the State's Attorney's Office in, if I'm not mistaken, the end of January of 1985. And the letter just basically said, I'm afraid of Mr. Cruz. I have some information regarding his case, and did not provide any substantive information other than that. And then the authorities did not talk to him, at least from what the reports indicate, until the beginning of March, at least more than a month later. And it's in these conversations and subsequent testimony, I guess, it's at sentencing where he said that Cruz would sing a song using the name Jeannie. Of course, Jones. There was a song that had been out several years prior by that title, and I'm trying to recall what else.
He said that Rolando was going to write a book about 5 ways to crush a skull or how
That's
to kill
correct.
little girls. And the most incriminating piece of evidence was that Rolando actually told him about Buckley and Alex dragging the girl up the stairs and raping her and doing all kinds of things to her, and supposedly Cruz was downstairs. If this was true.
Yeah, they took her to an abandoned farmhouse, and he also, I guess, supposedly says that Cruz told him that they never checked his shoes, or my footprints were in the mud or something, but they never checked my shoes. Of course, we now know that that's is not a part of the case, although they relied on it so heavily for so long. Pecoraro also, unbeknownst to us until just recently, was examined by a psychiatrist as a condition of his receiving probation after his conviction for theft of body parts. So he was obviously someone who required psychiatric care. And in his conversation with this psychiatrist, he basically says that the police are gullible. You can lie to them so easily. And
they were very gullible in this case.
Again, if I was a prosecutor and I had that information, and then I had a witness testifying in a capital case, I would more warning flags. Wait a minute, something's not right with this witness.
How did you find out this information? Because this came after the second trial, so the jury never knew about that. The state, though, knew about that.
Well, whether the actual prosecutors of the case knew, I can't say. However, the fact remains that this was a document in the possession of the state, the DuPage County Probation Department. It was something that was acknowledged as existing in his court file, and therefore I think you can impute that the state's attorney's office certainly should have been aware of it or was aware of it. Whether we would have been able to use the document at trial, I don't know. There are certain rules of evidence regarding that type of information. It certainly, I think, goes right to the heart of what Mr. Pecoraro was alleging that Mr. Cruz said, and again another symptom, another warning flag where you would have to look real hard at your witness before you put him on the witness stand if you know this information. I think the way this case was prosecuted, at least in the trial in which I was involved in January of 1990, was to analogize it to throwing as much mud as you can on the wall because something's going to stick. And I mean, they brought this Michael Ryan into court.
Who was Michael Ryan, by the way?
Michael Ryan, he's an individual who lives out in the Aurora area, right down the street from the police station. He's a sick man. He, not being a doctor, I can't say what he has, but he certainly looks like he exhibits symptoms of what they call the DTs, delirious tremens. He shakes uncontrollably. I don't know that it's Parkinson's. I mean, he's too young, I think. But he initially told the authorities right in the middle of the first trial that Cruz, I made some confession or some admission to him about a role in the crime. They chose not to use him at the first trial. Obviously, they assessed his credibility at that point and said, this fellow is not going to be a good witness for us. Once the Dugan evidence became part of our defense, well, their case was weakened, and maybe now it's time to try to use Michael Ryan. Anyone. Michael Ryan never made it as far as the vestibule of the court, I guess, and he fell. I wasn't there to see that, but I think the jury did, and maybe it left them with the impression that this man is terrified of Mr. Cruz. I don't know. I mean, so it didn't hurt the state, quite frankly, but he was not a credible witness.
Okay, now let's move on to the police stories. The police evidence against Cruz was a jail deputy chief who didn't necessarily incriminate Cruz, but he had an interesting story to say about Cruz 5 days after indictment, begging to talk to him,
yes,
to make a confession that Alex and Steve Buckley wanted him to do a burglary with them, and that he refused to do a burglary with them, so he said, I'll hotwire a car for you instead. And 2 days later, Buckley and Hernandez come back to him and say, would you like to have sex with a little girl. Now, this information, this story is naturally incriminating Buckley and Hernandez, but it's also incriminating Cruz because it shows that he is...
Well, he's part of the conspiracy before the crime by stealing the car, and he's concealing a crime by having knowledge, supposedly, of their holding a little girl.
Right, and then the same deputy chief has a similar story about Hernandez asking to talk to him again. 7 o'clock in the evening, Alex wants to make a confession to him, and Alex's story is the opposite. And that's 4 months after, well, it's in June 6th.
In June,
so it's 3 months later, that Alex wants to tell him that Cruz and Buckley and himself were going to do a burglary, and Hernandez got cold feet, didn't want to do the burglary. I don't know why he got cold feet, because Hernandez did do a few burglaries in his lifetime. Was he predicting a murder? And he asked to be put down under taken out of the car, and he stands under a tree in the middle of Naperville for half an hour while Buckley and Cruz are abducting a little girl.
Nobody would have noticed a Puerto Rican man standing under a tree in Naperville. I know, I mean, it's a ridiculous statement.
But these two statements were made by a police officer. Now, you have been a police officer. Isn't there an oath of some kind of a oath that a police officer has to take before?
Well, I mean, I was sworn in as an agent by a federal judge, that's correct, and without knowing the verbiage of the oath, I mean, I know I was to uphold the laws and to do it honestly. I don't know what occurred there. I mean, this has occurred in the jail. Why? This is post-indictment. Why weren't these gentlemen Mirandized? Meaning, why weren't their rights read to them? They're not. It's a custodial situation. They're talking to a law enforcement officer. They already have counsel because they've already. Well, I don't know if they've been arraigned at that point, so maybe they officially don't have counsel. But
Hernandez had counsel.
Hernandez had.
6th.
Okay.
Rolando had nothing.
Rolando had nothing at that point. The first thing, without, and I just don't want to discuss or even offer an opinion as to the veracity of Mr. Winkler's testimony, but just look at the supposed facts in their statements. It's completely inconsistent, impossible with what occurred. This poor little girl was dead within hours of being abducted. If this Lincoln was, it was a Lincoln, I believe, that was related. Continental was taken, stolen, hot-wired, used in the robbery, and then disposed of, burglary, and then disposed of. Well, there's no record of any theft of any Lincoln. There's no record of any disposal of any Lincoln at this junkyard or salvage dealer that he mentioned. It's just not true. It's not evidence of their committing the crime, as far as I'm concerned. It's a lie. I mean, if anything, it's obstruction of justice or perjury or something along that lines. But
how do you prove
it's ridiculous.
It? A police officer says it.
Well, yeah.
And let's move to the most incriminating evidence against him, and this is the vision statement he supposedly gave on May 9th of 1983, which depicted 6 different things that supposedly happened. Now, if this vision occurred, which we know it didn't occur, how come it was so organized?
that Mr. Cruz just enumerated these 6 specific points, which were not part of the what the public had about this case at that time. It sounds very contrived. When you look at it, I mean, on its face, the fact that it occurred supposedly on May 9th. There's no memorialization of it in any form or fashion. When it occurs in a police car, and then again at the police station where you have tape recorders, you have video cameras, you have pencils and paper, and there's no mention of it. And then it surfaces, first to the defense surfaces in, December of 1984, literally on the eve of trial, against a very weak defendant. Buckley was a weak case, obviously, but Cruz's case was very weak too, and now you have this, and you have two police officers saying it. The fact that the very next day Cruz allegedly gave a tape-recorded statement to them again at the jail,
totally unrelated matter.
where this vision is not even addressed. Just from my experience in law enforcement, if in May 9th of 1983, you've got a case that's going nowhere. You have no idea. I mean, they think these guys did it, but they have no hard evidence against them. And all of a sudden, one of the guys supposedly relates this detailed vision statement with such specific facts that, wait a minute, only a perpetrator could know this. Again, the flags would go up. I mean, if I was an agent, an investigator, and the suspect made a statement like that, I'd be excited because I've got a confession. I'd get the prosecutor in, I'd get this guy on paper, I'd tape record him, I'd do whatever I could to lock him in as to that statement. I just don't see even the worst cop, I can't see even the worst cop overlooking such an important piece of information.
It's mind-boggling, it really is.
It hurt us a great deal at the trial. I mean, the jury, let's face it, juries tend to believe police officers. And in my opinion, they should most often, because police officers, I think, typically are honest. Again, I'm not saying that these gentlemen lied. I'm just saying that if you just look at the supposed vision statement, it's ridiculous. I mean, plus it's inconsistent with their theory that she was killed somewhere else, because he talks about supposedly hitting her so hard that it left a depression in the ground. Well, they argue that she wasn't killed at the prairie path. I don't know. I mean, I laughed. That for me was just about the final straw as far as saying, wait a minute, this kid didn't do this. I mean, balancing it against the Dugan evidence. Oh my goodness! I mean, they've got the wrong guy.
So he is sentenced to death, and he is on death row, and he finally receives a second trial. And the Dugan testimony is allowed in just about in the 11th hour, just shortly before trial. They finally allow the Dugan testimony to come in. And some interesting things happened with the prosecution. They decided to look for some witnesses who could corroborate a new theory that, okay, Brian Dugan may have done it, but if he did it, he couldn't have done it alone. He has done everything else alone, but for some reason, this murder he could not have done alone. Okay.
Well, they were tailoring their case to the evidence that was there. It was a tactical move to diffuse our case by now contending that Dugan, Dugan had something to do with this, but so did Cruz. So it was a tactical move on their part. Okay, and how did they confirm this, or how could they prove that? Could you discuss Robert Turner? Robert Turner wrote a series of letters to the prosecution, and I think in his initial letter he indicated he had information on the cases of at least 10 death row inmates or something, some number like that, which I don't know. Everyone was confessing to Robert. Everyone was confessing. Plus, Robert Turner he had the biggest sword hanging over his head of any witness. Let's say we talked about Stephen Ford maybe being able to plead guilty to 1 burglary instead of 5 or 6. Well, Robert Turner is facing a death sentence, or a second death sentence. He's saving his life. My gosh, I mean, it's who knows what I'd do in that position. But if a man is capable of raping and killing a girl, as Robert Turner was, well, he's pretty capable of telling a lie against a guy like Rolando Cruz without blinking an eye, which he did. Right. What did your investigation show? First of all, I know that they were not friends, and Rolando, as a matter of fact, didn't like him. I think that was Rolando's opinion of Mr. Turner. Inmates on death row are in a very controlled environment. Literally, when they leave to brush their teeth, it's logged in. Every little thing they do is noted. It's hard for me to believe that there were 5 or 6 occasions when Cruz and Turner were in the yard, meaning out on the campus, if you will, of the prison. Did the logs show that he was never out? The logs showed that they were not out together during the time period when Robert Turner says these conversations took place. Mm-hmm. And again, what is more important about that is that the state never attempted to corroborate Turner. They never attempted to get these logs. And the first they knew of them, or the first they saw of them, I should say, was when we presented them to them. We subpoenaed them. They didn't. And whether they just didn't want to look at them, because it's, with a witness like this, you put your blinders on, again, you throw him on the wall, he's more mud, and hopefully some of him will stick, which it apparently did.
And his testimony was probably the filthiest, the most insidious against Cruz. Steve McClure was an angel compared to...
Turner's testimony was graphic with respect to the assault of the little girl. It also played on race because there was a reference to the girl being white, and we all know Mr. Cruz is Mexican. He's the kind of witness where, based on my experience, having worked with people who I think have the most integrity of anyone in law enforcement, that being the U.S. Attorney's Office for the Northern District, you would polygraph a witness like this just for your own personal satisfaction. You would do everything in your power to corroborate him.
And this is probably the most important thing that the public and the jury should know. None of those witnesses were ever polygraphed. If they were polygraphed, I think there would be no case against Mr. Cruz.
Well, I mean, a lot of people, opinions differ on the value of a polygraph. I'm one who happens to believe in it.
Well, if you really want to know who did it, I mean, we are talking about a capital case. We're talking about millions of dollars to taxpayers.
Correct.
And I think state attorneys have to consider this. If you are prosecuting someone, please prosecute the right person. It's going to cost money.
I think it's their duty to do that. That's correct. I mean,
so you polygraph them once, twice. There's a couple very good polygraphers here in DuPage County. So you take them to two polygraphers.
Well, they took one witness to a polygrapher. I mean, but then they took Mares to a polygrapher.
Because he wanted.
Right, and he, I guess, was borne out on a couple of his questions as being truthful. But it's whether you'd polygraph some of the lesser witnesses, I don't know. But Robert Turner, in my mind, there's no question you should do that. Again, you attempt to corroborate a witness like that as far as you can, and they didn't. Now, whether it's nonfeasance, I don't know. I mean, that's what they did. We're stuck with it right now.
The funniest story is the story of Irma Rodriguez. They were still grappling and trying to find some connection between Cruz and Dugan. Can you tell the Irma Rodriguez story?
Irma Rodriguez is Rolando Cruz's first cousin. She lives in the east side of Aurora. And she lives in a house which is next door to a house where Brian Dugan once resided.
For 5 months.
For 5 months, roughly between July and November of 1984. That was borne out by the rent records that the landlord provided. They were informed of Ms. Rodriguez by Ramon Mares. And they talked to Ms. Rodriguez, and she indicated she knew Brian Dugan and she knew Rolando Cruz. And in their report, the report of the detective, there's a statement attributed to her that she saw Rolando and Brian Dugan together on 2 occasions. It turns out, I mean, that's just not the case, and Ms. Rodriguez has gone on record and testified that that's not the case. She realizes now that Rolando Cruz was incarcerated from August of 1983 and that she did not meet Brian Dugan until roughly July of 1984.
A year later.
Mr. Cruz has been in since then and hasn't seen the light of day since. So she did not see them hanging around together.
In fact, she said in the witness stand, that was a white guy, a blonde guy.
A white boy who a blonde guy. We believe we know who it is, but it's not Brian Dugan.
Right.
That's the bottom line. And she talked about Cruz stealing Brian Dugan's dog. It couldn't have been, because Brian Dugan didn't live there until after Cruz was in jail. It would have been difficult for him to do that.
Yeah. There's a lot of very funny things in this particular story, which regretfully we can't go into in 1 hour. Would you like to talk about Cruz? I mean, you know Rolando very well. I know him very well. But and at some point I will share my knowledge of him. But would you like to talk about him a little?
Well, I've gotten to know him. He's a very emotional fellow. He's pretty sincere. I mean, I'm impressed with that, and he's very attentive. he can tell you just about every detail of his trials, literal trials.
He has everything memorized.
He does. He's an encyclopedia. If I have a question, he's the first person I'd ask rather than go look through the records, because he can point me to the right file or the right witness. He's incredibly patient for what's happened to him. I mean, I don't know that I could. I guess you have to sit and bide your time, but.
I think religion has helped him.
Yeah, he's gotten religion, as they say, since he's been incarcerated, and I think it has. You need something while you're in there. There's no question. Somebody.
But you know, Cruz was interested in religion for some time before his incarceration.
He had tried. I guess he was Catholic originally, but he had tried what, Pentecostal?
Pentecostal and Presbyterian.
Okay.
And he was very interested in comparing the theologies of those different religions, and he actually went to different Bible studies 3 or 4 times a week the year after his release from the Army.
Unusual for a teenager, at least from teenager when I was a teenager.
And
That's certainly not
hours with me discussing
our
theology.
priority. Okay, I mean that's interesting. That's impressive. That certainly doesn't bear out the character of a man who can rape a little girl and kill her. But I mean that's certainly not enough to say he's innocent. But yeah, I was impressed by that. I mean, I just didn't see that when I was growing up among my peers, and
the description of Cruz in the grand jury was a liar, a thief, not to be trusted, a big talker. Some of it could have, was true.
Well, the big talker part, I mean, there's no question he's a big talker, and there's no question his talk got him into a little trouble here. Yeah, but I mean, again, it's almost consistent with our case. Yeah, this guy talks. I mean, he's complete puffery. He says things that are not true.
What did the state try to present to the jury in the second trial at sentencing as far as discrediting his personality?
Again, I was not in the courtroom for that part of it because I was out marshaling witnesses, our witnesses, because we put on quite a bit of mitigation. Their general argument was that he was a gang member, that he was a burglar, that he was one other thing I'm trying to. That escapes me right now. That he showed no remorse for the crime.
Can we look at those 3 main accusations?
I don't know that Mr. Cruz had any gang affiliation prior to his going to prison. It
was more a social type thing.
Yeah, I mean, it's not like they found a Latin King's jacket in his apartment. I mean, if they did, they would have stuck it in front of the jury's face. Yeah, it's not very clear to me that he was a gang member, but he's a Mexican American from the east side of Aurora, and right away you start off. We had 10 or 11 white jurors. Sure, I mean, it's not hard to convince them that this kid might be a gang member.
Okay.
Not hard.
What about a thief? I mean, the state used Barrel, Marquez, hundreds of thefts, and they had no problems dealing with those people and giving them wonderful light sentences. But compared to those guys, Rolando Cruz was probably a choir boy.
If anything, he was a petty thief. If anything, I mean, I think he's got one conviction for a theft, not even a burglary. That's a distinction. I mean, to me, burglary versus theft. I mean, I can steal a wallet laying on a car seat, but to go to the extent of committing the burglary, breaking and entering into a house and doing something, well, I mean, he wasn't convicted of that. I know he was. He had a lot to deal with.
He loves his family, and he loves his mother and his sisters and his nieces and nephews. And
he's very devoted to his family. I found that out too. I mean, I happened to be with him on the evening after the verdict in the second trial, and I spent the whole night with him and Mr. Gabrielson.
Where were you?
We were at the Rockford Jail, the Winnebago County Jail. Yeah, we went in there about midnight and stayed till about 4 or 5, and it was tough for all of us. I mean, I felt badly for the kid. I mean, we
You're a
felt like we let him
person
down.
who's a pro-death penalty.
I'm an advocate of the death penalty, not as a deterrent, but simply because some people do things that are so bad that I don't want them around. I don't want to pay for them. But
Well, you do pay.
I know you do pay to have their appeals litigated. But
what does this case do to you as far as your opinion on the death penalty?
I don't know that it changes it. I'm still an advocate of it, I think. However, it's like nobody can believe that an innocent person can be convicted and sentenced to death twice. I mean, that's, again, looking back to the two juries that convicted him, you have to look cockeyed and say, wait a minute, no way that could be. But it is. I mean, in this case, I'm convinced of that. And it makes me look at everything with a lot of caution, and I'm never going to, I will never assume as much as I had in the past. But.
Do you think juries are able to determine such a major decision as far as guilt or innocence?
Jurors are interesting in the way they do it. To be a fly on the wall would be great. I mean, I know that in just a case that I'm familiar with in past years, a juror was convinced of the guilt of the defendant, but another juror wasn't. This other juror was badgered by the foreperson, and another juror to the extent that she gave in and, okay, the defendant's guilty. And then this other juror, who was already convinced of their guilt, said, wait a minute, on principle, I'm going to hold out, and that juror did.
Okay.
It's just saying how juries work. It's amazing the way they reach compromises, and they...
Well, let me tell you something, and this is really scary. In the first trial, the jury foreman said, well, if they're here, they must have done something. And this he said at the very beginning of the trial.
Okay. The presumption is so strong of guilt going in. I mean, the law is presumed innocent until proven guilty, but the presumption is so strong that a person is guilty when they are brought up for trial. And again, the state usually doesn't make mistakes. I mean, I still believe that their mistakes are not as frequent as maybe some people think. They do make mistakes, though, as borne out by this case. Mm-hmm. And yeah, there's no question jurors in these cases went in thinking that. I mean, this was a Rockford jury. I mean, this is a Republican county, Winnebago. These are people who are probably law and order. These are people who, yeah, would think that, sure, the prosecution wouldn't bring this case if they didn't believe this guy did it. So I'm going to assume he did it until the defense can show he didn't. So I think they reverse it right away. A lot of them do. Maybe not every juror, but you heard it yourself. Yeah, so that's how it works.
I think jurors have to get some training. When I began researching this, I took the wrong route. I began by reading the newspaper articles. So you want to get a little of this and a little of that. And I thought they were guilty. Until I began reading the transcripts, and I could read through the lying. I could just see that this, one and one don't match. They just don't add up to two.
I mean, the state made a good case out of this, but they made the wrong case. And I just think that...
and the suffering of the families. I see the mothers.
Well, it's hurt everybody. I mean, it's hurt the victim's family. There's no question about it. I mean, they have to go through this thing for 7 years now. And whether that's not our fault as far as I'm concerned. That's the state's fault for bringing a case against the wrong guys. Or at least for not having admitted that they brought a case against the wrong guys at some point after the Dugan information was first revealed. And yeah, it's terrible all around.
It's rather ironic that Dugan's serving a life sentence for 3 murders and numerous rapes, and Cruz is going to lose his life, could lose his life for doing nothing.
It's a sick irony. It is frightening. But the way I look at it is that we will just do things better in the 3rd trial. I'm convinced that we will get another opportunity.
Well, we have to.
And it's hard to fathom that of the 3 original defendants, 1 is not charged, 1 a jury cannot decide his fate, and 1 is facing death. And then another guy has still confessed to the crime, and
no one will bring him to trial for it.
And no one will, yeah, exactly, no one will bring him to trial. So, I mean, it shouldn't happen that way, but it is right now. But
no.
well, it's
Happens occasionally.
It's a fluke. I mean, it's just a fluke, and it's there. But like I say, I'm confident that this case will not end here. The only unfortunate thing is that Mr. Cruz has to wait again.
Well, he's utilizing his time very well.
It sounds like it. He's
really
looking into correspondence courses. He told me he's working out quite a bit. He's getting his prowess at lifting weights back to what it was and his prior stretch down there.
He's so excited about this.
Yeah, it's tough, but I feel we let him down a little. There's no question that you do. I mean, your personal ego suffers when you lose a case that you feel you should win, but yeah, it's not going to get in the way of going at it the next time and doing things better. It's just that the longer this guy sits, the more chance that an inmate-type witness can pop up and say that he said something else about the crime. But I don't know. I mean, I just...
in this case, it seems to happen rather often.
How can guys who are smart enough to not leave any physical evidence but one footprint at the scene, who are smart enough to get a car, use it, and then dispose of it without anybody being able to trace it in any way, how can they be foolish enough to, and not to be seen anywhere around, be foolish enough to make statements to, I mean, that's what I mean, it's so inconsistent. I got the impression during the trial and at the verdict and sentencing that from the members of the press who attended regularly that, it basically was, I don't know whether your guy did anything or not, but he shouldn't be convicted. I mean, they're trying to be as objective as they can, I guess, but they were still of the opinion that this was not a case that should have resulted in a guilty verdict.
Thank you very much.
You're welcome. You're welcome. My pleasure.
Let's hope we'll meet in happier occasions.
Yeah, definitely will. I know.